William Marbury lost his case. Chief Justice John Marshall did not rule in his favor. Yet the Supreme Court emerged with more power than it entered the room with. Washington City, District of Columbia, Supreme Court Chamber, February 24, 1803, Monday, 10 a.m. What followed was not a victory recorded in the verdict. It was authority claimed in silence. Washington City, District of Columbia, Supreme Court Chamber, February 24, 1803, Monday, 10 a.m. The room was already full when the justices entered, not crowded in the way popular trials would be later described, but occupied. Every bench taken, every wall lined with quiet observers who had arrived early and without instruction. There were no printed notices announcing the importance of the morning, no flags, no ceremonial arrangements, no expectation that the session would reach beyond its docket. Those present later recalled that most believed they were witnessing a procedural dispute, the kind resolved and forgotten within the same term. The chamber itself offered little drama. High ceilings, plain wooden surfaces, daylight filtering through tall windows that softened rather than sharpened the space. Sound traveled easily. Every footstep registered. Every shift of weight echoed faintly. Conversations, where they existed at all, were reduced to murmurs that stopped when a door opened. There was no applause when the justices took their seats, no call for attention beyond the clerk's voice reading the order of the court. The atmosphere was not tense so much as uncertain. The federal judiciary, still young, still defining its boundaries, was not yet assumed to be the final voice in disputes between citizens and the government. Many in attendance regarded the court as an administrative necessity rather than a decisive authority. William Marbury was already present. He did not stand out. Witnesses described him as composed, dressed conservatively, neither defiant nor deferential. He carried no visible documents into the chamber, no entourage, no sign that his name would later become inseparable from constitutional law. To those seated nearby, he appeared as one more litigant among many, patient, attentive, and silent. The justices themselves offered little indication of what the day would bring. Their expressions remained neutral as they arranged papers and settled into position. Chief Justice John Marshall took his seat without ceremony. There was no immediate hush beyond what decorum already required. No sense, at least on the surface, that the court was preparing to confront its own limits. Observers later noted how ordinary the opening minutes felt. The clerk read the case title in a steady voice. The language was formal, restrained, stripped of implication. The matter concerned an undelivered commission, an appointment made but not received, a question of obligation rather than power. Nothing in the phrasing suggested constitutional consequence. Yet beneath that procedural framing, something unsettled the room. Several witnesses recalled a quiet shift, an awareness that the court was being asked to respond to more than a private grievance. The recent change in administration lingered unspoken in the chamber. Political tension existed, but it was not articulated. It remained suspended, present without acknowledgement. Marshall listened without interruption. He did not lean forward or confer with his colleagues. He did not signal interest or skepticism. His posture remained consistent, his attention complete but unreadable. Those accustomed to judicial performance noted the absence of visible strategy. He asked no preliminary questions. He allowed the proceedings to unfold at their own pace. Marbury, for his part, offered nothing extraneous. He did not frame his presence as a challenge. He did not appeal to public sentiment or political allegiance. His claim, as understood by those present, was narrow, that an appointment properly made had not been honored. It was an argument rooted in process, not ideology. The court accepted the framing without correction. For several minutes, the chamber functioned exactly as expected. Words were exchanged, records referenced, and the mechanisms of law moved forward with routine precision. The crowd listened, attentive but unanimated. No one took notes with urgency. No one shifted to gain a better view. Only later would participants agree on this point. Nothing about the beginning suggested where the case would end. The Supreme Court had convened to resolve a dispute. It had not announced an intention to define itself.
The origin of the dispute was not dramatic. Those who later retraced its beginnings described it as administrative, almost forgettable, a matter that would not normally have reached the Supreme Court at all. It began in the final days of an outgoing administration during a period when paperwork moved faster than confirmation and intention outpaced execution. Judicial commissions were prepared in bulk. Names were written, positions assigned, documents signed and sealed. The process followed established custom. Nothing about it suggested conflict. Several appointments were completed without incident. Others remained unfinished when the transfer of power occurred. The distinction between the two would become critical only in hindsight. William Marbury's commission was among those left in transition. Witnesses familiar with the process testified later that the appointment itself was not contested. It had been authorized. The seal had been affixed. The paperwork had been prepared. What remained was delivery, an act considered routine, procedural, almost ceremonial. No one at the time identified it as a point of vulnerability. The change in administration interrupted that final step. New officials assumed office before the remaining commissions were distributed. The documents did not move forward. They were neither returned nor destroyed. They simply remained undelivered, their status unresolved. For most affected appointees, the matter ended there. Silence replaced expectation. Marbury did not let it pass. Those who knew him described his response as measured rather than reactive. He did not protest publicly. He did not appeal through political channels. Instead, he sought clarification through the mechanisms available to him. When none came, he turned to the courts, not to make a statement, but to obtain what he believed had already been granted. At first, the matter drew little attention. Within legal circles, it was discussed as a narrow question of entitlement. Did an appointment become valid upon signing and sealing, or only upon delivery? The issue carried technical significance, but little perceived consequence. It was assumed that resolution would follow precedent, whichever way it leaned. What changed was not the claim, but the context. The case advanced quietly, passing through preliminary consideration without commentary. By the time it reached the Supreme Court, it did so stripped of political language, framed as a private grievance rather than a constitutional challenge. The court accepted it under that understanding. Observers later emphasized how ordinary the referral seemed. There was no surge of interest from newspapers, no surge of spectators seeking spectacle. The case did not arrive with expectation of confrontation. It arrived because it fit within the court's jurisdiction as it was then understood. Yet within the chamber, awareness began to shift. Those attentive to recent political transitions sensed that the dispute could not remain isolated. The commission represented more than a document. It embodied authority granted by one administration and withheld by another. Deciding its status meant addressing the boundary between executive discretion and legal obligation. Still, none of this was spoken aloud. Marbury remained a private citizen in posture and presentation. His claim was personal, not ideological. He asked for the commission, not for a ruling on executive power. That distinction mattered to him and to those who watched him closely. The court, however, could not ignore what the case implied. As records were reviewed and arguments prepared, it became apparent that resolving Marbury's claim required answering a question the judiciary had not yet answered for itself: whether it could compel action from the executive branch when law and administration diverged. The issue arrived quietly. No one announced its significance. No one labeled it historic. But by the time arguments were ready to be heard, those closest to the case understood that the dispute was no longer about a single commission. It was about whether the court could say what the law required and expect that answer to stand. When Chief Justice John Marshall spoke, the chamber adjusted around him. Not abruptly, not theatrically, The shift was subtle. Voices lowering without instruction, movements slowing, attention narrowing toward the bench. Those who later described it struggled to identify a single moment when authority asserted itself. It was not announced, it was assumed, then accepted. Marshall did not fit the image many expected. He was tall, but not imposing by posture. His presence did not rely on physical emphasis or vocal force. Witnesses recalled a deliberate economy in his movements, papers aligned carefully, hands still when not in use, eyes moving steadily between counsel and colleagues. Nothing about his demeanor suggested urgency, nothing suggested uncertainty. His reputation, however, preceded him. By 1803, Marshall was already known as a careful strategist rather than a reactive jurist. He had argued before courts, negotiated abroad, and served within government at levels that gave him a practical understanding of power beyond theory. Those familiar with his history understood that he did not treat the law as abstract. He treated it as something that had to function within the realities of governance. That awareness shaped the room. Attorneys present moderated their tone. Observers leaned forward slightly, listening not for rhetoric, but for structure. Even the justices seated beside him appeared attentive to his pacing. The court operated as a collective, but it was clear where direction would originate. William Marbury stood in quiet contrast. He was neither young nor particularly distinguished in appearance. His posture remained neutral, his expression unreadable. He did not scan the room or seek acknowledgement. Those nearby noted that he appeared attentive but not anxious, aware of the stakes as they applied to him personally, but not anticipating anything beyond that. The imbalance between the two figures was evident. Marshall represented the court, but also the institution behind it, still forming, still contested, but increasingly aware of its position within the federal structure. Marbury represented a claim that had followed the rules as written and stalled at execution. One carried authority by appointment, the other by expectation. Yet the dynamic was not adversarial. Marshall did not treat Marbury as a challenger to the court. He did not frame the proceeding as a test of strength. Instead, he allowed the case to remain what it appeared to be on its surface, a legal question seeking resolution through established process. That restraint was noted. Several observers later remarked on the absence of confrontation in the opening exchanges. Marshall asked questions sparingly. When he did, they were narrow, directed toward clarification rather than challenge. He allowed counsel to speak without interruption, even when arguments circled familiar ground. This was not passivity. Those experienced in judicial proceedings recognized the discipline in his approach. Marshall was gathering structure, not reaction. He was mapping the argument as it presented itself, identifying where it held and where it thinned. His silence functioned as assessment, not acquiescence. The room followed his lead. Tension did not rise through conflict, but through anticipation. The audience sensed that something was being held back, not concealed, but reserved. The case was proceeding, yet not resolving. Each point raised seemed to invite a larger question that remained unspoken. Marbury's role diminished as the hearing progressed, not because his claim weakened, but because its implications expanded beyond him. His presence became a fixed point against which broader considerations aligned. He did not resist this shift. He did not attempt to reclaim the focus. He remained still, allowing the process to move where it would. Marshall noticed. Witnesses later recalled moments when the Chief Justice paused slightly longer than necessary before responding, not enough to draw attention, but enough to register with those watching closely. These pauses suggested calculation, not hesitation, the kind of silence used to test whether the room was ready to follow.
By the end of the session, authority had not been asserted through declaration. It had been established through control, of pace, of framing, of what was allowed to remain unresolved. The court had not yet spoken decisively, but under Marshall's guidance, it had positioned itself to do so. And in that positioning, some present sensed the beginning of a shift, not in the case alone, but in the court's understanding of itself.
The arguments resumed without fanfare. There was no announcement that the court intended to move beyond the narrow dispute before it. No indication that the session would depart from the familiar sequence of claim, response, and resolution. To those seated in the chamber, the proceedings still resembled a conventional hearing, measured, orderly, contained. Yet the direction had begun to shift. The initial questions concerned the commission itself, whether it had been lawfully created, whether its validity depended on delivery. Counsel spoke carefully, grounding each assertion in precedent and statute. The language remained technical, precise, stripped of implication. On the surface, the case continued to revolve around a document. Then, Marshall reframed the inquiry. He did not do so with a declaration or a rhetorical turn. Instead, he posed a question that seemed procedural, almost incidental. If a right had been established, and if that right had been violated, what remedy did the law provide? And if the law provided a remedy, which institution was empowered to enforce it? The chamber grew quieter. The question did not challenge the argument already presented. It expanded it. Witnesses later described the effect as gradual rather than immediate, a realization unfolding in stages. The court was no longer being asked merely to determine whether Marbury was entitled to his commission. It was being asked to decide whether it could compel an executive officer to act. No one responded at once. Counsel adjusted their footing, returned to their notes, recalibrated their language. The shift required care. Addressing the question directly meant confronting the boundary between branches of government, a boundary that had been acknowledged in theory but rarely tested in practice. Marshall remained still. He did not press the point. He allowed the silence to settle, then listened as responses formed cautiously. Arguments were offered, qualified and hedged. References to statute were paired with acknowledgments of limitation. The law, it was suggested, could define obligations, but enforcement against executive discretion raised concerns. Marbury remained silent throughout. Observers noted that his role had become almost symbolic. The case still bore his name, but the discussion had moved beyond his circumstances. He did not interrupt. He did not attempt to redirect attention. His stillness underscored the shift taking place. What was being examined now was not his grievance, but the court's reach. The justices exchanged brief glances, not signals, but acknowledgments, the kind that occur when a shared understanding begins to form without articulation. The question before them was no longer whether a commission had been wrongfully withheld. It was whether the judiciary could declare an act of the executive unlawful and provide a remedy when it did. This was not a question the court had answered before. The Constitution spoke of judicial power, but not in exhaustive terms. Statutes granted certain authorities, but not without ambiguity. To decide the case as framed would require interpretation. To answer the larger question would require definition. Marshall allowed the distinction to remain visible. He did not collapse the issues into one. Instead, he separated them: right, violation, remedy, authority. Each step was examined in sequence, each dependent on the last. The structure itself suggested a method of reasoning that extended beyond the immediate case. The audience sensed the shift even if they could not yet articulate it. Later accounts described a feeling of suspension,
as though the room were holding its breath without realizing it. There was no overt tension, no raised voices, but the certainty that had accompanied the opening of the case had dissolved. By the time arguments concluded for the day, the matter before the court had changed shape. The dispute that entered the chamber as a private claim now carried a public question, not announced, not labeled, but unmistakable to those paying close attention. The court had not yet answered it, but it had acknowledged that the question existed.
When the court reconvened to deliver its opinion, the chamber was quieter than before. Not emptier, attendance had not declined, but more restrained. Those present sensed that the case had moved beyond ordinary resolution. The earlier uncertainty had settled into expectation, though few could have articulated what they expected to hear. Chief Justice Marshall delivered the opinion. He did not raise his voice. He did not pause for emphasis. His words were measured, deliberate, arranged with the same structural care that had guided the court's questioning. Listeners later recalled that the opinion felt less like an argument than a sequence, each point following from the last with controlled inevitability. He began where the case had begun. William Marbury, Marshall stated, had been properly appointed. The commission had been signed and sealed. In legal terms, the right existed. This acknowledgement passed through the room almost unnoticed. It confirmed what most had assumed from the outset. He continued. The failure to deliver the commission, he concluded, constituted a violation of that right. The law, as written, did not permit such an omission once the appointment had been completed. At this point, the reasoning aligned fully with Marbury's claim. Observers later noted that nothing in these opening conclusions suggested defeat. Then Marshall turned to remedy. The question, he explained, was not whether Marbury had been wronged, but whether the court was empowered to provide the relief he sought. Specifically, whether it could issue a writ compelling an executive officer to act. This distinction reframed the outcome before it was delivered. Marshall examined the statute that appeared to grant the court that authority. He did so carefully, without dismissal. He acknowledged its intent and its language. Then, with equal care, he compared it to the Constitution. Where the two diverged, he stated, the Constitution must prevail. The court, therefore, could not exercise a power that exceeded its constitutional grant, even if a statute purported to confer it. The conclusion followed without ornament. The court lacked jurisdiction to issue the writ. Marbury's request was denied. There was no audible reaction, no murmur of approval or dissent. The ruling had resolved the case, but not in the way many had anticipated. Marbury lost his commission not because his claim lacked merit, but because the court declared itself unable to act on it. Yet the decision did not end there. In the same opinion, Marshall articulated a principle that extended beyond the immediate outcome. It was the duty of the judiciary, he stated, to say what the law is. When a law conflicts with the Constitution, the court must follow the Constitution and disregard the conflicting statute. This assertion was delivered without flourish. Marshall did not frame it as a claim of supremacy. He presented it as a necessity, an obligation inherent in judicial function. The language was restrained, almost instructional, but its implication was unmistakable. The court had defined its role. By refusing to act where it lacked constitutional authority, it had simultaneously asserted the authority to interpret the Constitution itself. The denial of Marbury's remedy became the mechanism through which the court claimed a broader power. Observers later described the moment as disorienting. The outcome felt both limiting and expansive. The court had restrained itself in the specific case, yet elevated its position within the structure of government. No celebration followed, no acknowledgement from the bench. The opinion concluded, and the session moved toward adjournment. William Marbury did not react. Those seated near him recalled no visible response, no frustration, no acknowledgement, no appeal. He had come seeking a commission. He left without it. His role in the proceeding ended there. The room remained still as the justices withdrew. Only afterward did the implications begin to circulate. Conversations resumed cautiously. Legal observers compared notes, not on the verdict, but on the reasoning. The ruling had denied relief,
but it had also altered the ground on which future disputes would stand. The ruling did not announce a new era. It simply stood, and in standing, it claimed more than it withheld.
The immediate response was silence. Not the kind that follows confusion, but the kind that settles when there is nothing left to add. The opinion had concluded without flourish, and the court had risen without pause. Those present remained seated for a moment longer than custom required, as if waiting for an acknowledgment that did not come. Government officials did not speak publicly that day. No statements were issued, no rebuttals prepared. The decision had denied a private claim while simultaneously asserting a judicial principle that did not invite immediate challenge. To contest it would have required engagement on constitutional ground, and no one present appeared ready to do so in the moment. Legal observers divided quietly. Some regarded the ruling as restrained, an example of the court declining power rather than seizing it. Others recognized the reasoning as something else entirely. They noted that the court had resolved the case in a way that insulated itself from direct conflict while establishing interpretive authority that would shape future disputes. These differences surfaced in conversation, not proclamation. In the chamber's corridors, attorneys spoke in lowered voices. Judges conferred briefly, then separated. Reporters, accustomed to decisive verdicts, struggled to frame what had occurred. The outcome did not lend itself to headlines. It lacked spectacle. It offered no immediate consequence beyond the parties involved. William Marbury departed without notice. There was no formal dismissal, no exchange of words with counsel. He left as he had entered, quietly, without acknowledgement. Witnesses later recalled that his presence seemed to recede almost instantly, as though the case bearing his name had already moved beyond him. The focus shifted to the court, not outwardly, but in reflection. Those familiar with constitutional theory recognized that the decision had settled a question that had lingered unresolved. Whether the judiciary could interpret the Constitution in the face of conflicting law was no longer hypothetical. It had been answered, indirectly but definitively. Yet uncertainty remained. Some questioned whether the assertion would hold. The court had spoken, but its authority still depended on acceptance by the other branches. There was no enforcement mechanism attached to the ruling. Its power rested in reasoning alone. That uncertainty did not produce immediate resistance. Instead, it produced restraint. No official action contradicted the decision. No statute was amended in response. The executive branch adjusted without comment. The absence of reaction became its own confirmation. Within legal circles, the case began to circulate differently. It was not cited for its outcome, but for its method. Scholars and practitioners examined the structure of the opinion, the sequencing of its conclusions, the way it reached beyond the dispute without appearing to do so. The decision became a reference point rather than a resolution. Public attention remained limited. There were no gatherings, no public demonstrations, no widespread debate. The significance of the ruling was not immediately apparent outside professional circles. It lacked the qualities that typically marked turning points. And yet, something had shifted. The judiciary had spoken in a way it had not before. It had declined a remedy while defining a role. It had ended a case while opening a framework. Those who understood this did not celebrate it. They noted it, recorded it, and waited to see whether it would endure. By the time the chamber emptied, the case itself was already receding. What remained was the reasoning, and the recognition, quiet, uneven, but persistent, that the balance between law and power had been recalibrated without ceremony. In the years that followed, the case did not announce itself. It was not invoked in speeches or commemorated in ceremony. No marker identified the moment when its significance became fixed. Instead, it appeared gradually, embedded in legal argument, cited without explanation, treated as settled long before it was widely understood. The name attached to the case began to separate from its facts. William Marbury's personal grievance faded quickly from memory.
His commission was never delivered. His role in public life did not expand as a result of the litigation. In legal study, he became less a person than a reference point, a name affixed to a principle that no longer depended on him. The court's reasoning endured. Judicial review, once articulated, was not revisited as a question. It entered legal practice as an assumption. Courts referenced it not as an innovation, but as an existing condition. Law students encountered it early, often without context, learning its conclusion before understanding its origin. Over time, the absence of controversy became part of its authority. The decision was not enforced through confrontation. It did not provoke a constitutional crisis. Its strength lay in its acceptance, first by legal professionals, then by institutions, and eventually by the public record. It held because it was used. When later courts struck down statutes, they did so without revisiting the foundation. They cited the principle as settled law. The reasoning traced back to 1803, but the act of citation carried no sense of return. The origin became background, its circumstances secondary to its function. Historians would later remark on this quiet permanence. They noted that the most consequential assertion of judicial authority in American history occurred without spectacle. No branch openly conceded power. No formal transfer took place. The balance shifted because one institution articulated its role with precision and others did not contest it. The legacy settled unevenly. Some praised the decision as a safeguard against legislative excess. Others questioned the concentration of interpretive power in an unelected body. These debates surfaced periodically, often during moments of national strain. Yet the underlying principle remained intact. The case itself became a point of reference rather than a subject of dispute. Its language was analyzed, its structure dissected, its outcome taught as inevitable. Rarely was it remembered as uncertain, contingent, or restrained. The quietness of its delivery receded from view, replaced by the clarity of its effect. What remained was not the drama of a courtroom, but the framework it left behind. A judiciary empowered to interpret the Constitution, a precedent established without enforcement, an authority claimed through reasoning rather than command. The chamber where the decision was delivered did not preserve the moment. No record captured the silence afterward. No account fixed the expressions of those present as the weight of the ruling became clear. That silence, like the ruling itself, passed without notice. And yet, it endured. Not as a story retold aloud, but as a foundation assumed, present in every constitutional question that followed, standing quietly beneath the law.
Long after the principles were gone, the silence surrounding the case remained. Not as absence, but as structure. The kind that shapes behavior without announcing itself. Courts did not ask whether they possessed the authority articulated in 1803. They acted as though it had always been there. Legislators drafted laws with an awareness, sometimes explicit, often implicit, that their work would be measured against a constitutional standard enforced elsewhere. This adjustment was not formalized. There was no amendment ratified in response, no statute clarifying boundaries. The constitutional text remained unchanged. What evolved was practice. The judiciary assumed a role through repetition, and repetition conferred legitimacy. In later decades, the principle was tested indirectly. When statutes were invalidated, when executive actions were restrained, the reasoning traced back through layers of precedent to that early articulation. Rarely did courts revisit the moment of origin. They relied instead on accumulation, the weight of decisions that followed. The original case receded further. Its facts became compressed into a paragraph, its participants reduced to names. The tension that once existed between branches was remembered as theoretical rather than lived. What had once been uncertain became foundational. Scholars noted the paradox. The court's authority expanded most when it appeared restrained. By denying relief in a politically charged dispute, it avoided immediate confrontation. By explaining why it lacked power in that instance, it defined the scope of its power in all others. The silence that followed was not indifference, it was acquiescence. Over time, the absence of challenge became confirmation. Each unopposed decision reinforced the premise. Each citation without objection solidified the structure. Judicial review did not persist because it was dramatic or popular. It persisted because it became necessary to the operation of law. The legacy, then, was not a ruling, but a habit of review, a habit of comparison, a habit of treating the Constitution as a standard against which all other law must answer. Those habits outlived the moment that produced them. By the time the case was widely recognized as foundational, its quiet origin was largely forgotten. The slow pace of its delivery, the lack of reaction, the uncertainty in the room, all of it faded beneath the clarity of what followed. What endured was not the sound of a gavel or the force of a command. It was the steady presence of an idea, spoken once, accepted gradually, and left standing. The case ended in silence. The structure it created did not.